Wednesday, September 26, 2018 of the North Broward Hospital District to order. Would you please do roll call? Yes.
War?
Here.
Commissioner Klein?
Here.
Commissioner Uri?
Here.
Commissioner Wellens?
Here.
Commissioner Berry?
Here.
Do we have any public comments?
Before we get to public comments, I have a point of order. The agenda that has been circulated to those in attendance here does not match the agenda that was circulated to the commissioners in advance of the meeting and the agenda that is posted on our website. So in order to avoid a potential public meetings notice violation, I make a motion that we abide by the agenda that's been previously distributed and published.
So from a legal standpoint, as everybody knows, the agenda is not required by law, certainly not at a committee level. The committee has no ability to take action. So you may proceed with whatever agenda items the chair of legal and affairs would choose to do. Anything could be discussed also at the board afterwards. So board can, chair, you can decide.
Well, let me ask if there's a second to the motion.
The agenda, I could elaborate, the agenda that was just distributed to us as we arrived here today,
The motion fails for lack of a second.
I'm explaining the motion, does not match the agenda that was published and circulated to the commissioners in advance of the meeting, as we had all agreed was proper governance and proper procedure under the Sunshine Law.
Well, let me address that for a second. I originally formatted this
Well, the motion's been
agenda.
made.
Chairman Klein took it upon himself to change my agenda, and then I changed the agenda back to what I wanted on the agenda. That is how that came about.
And when did that transpire?
I have all three copies.
Okay. So you deleted the item dealing with explanation of fiscal year 2018 law firms charges, which I had requested to be added. Is there a reason why you deleted that item?
Yes, you got the information that you wanted.
No, I did not.
I believe Ms. Barrett gave you a list.
She did not.
Well, I'll clarify. Well, first of all, is there a second to the motion? Otherwise, it dies.
I don't hear a
I'll second the motion only because I just don't really know exactly what the difference is. I only have what I was sent. It just came to my home, so that's what I went through.
So if each commissioner can take
I don't know
a...
which agenda is the agenda.
Commissioner Berry, do you want to clarify your agenda was for the board meeting as opposed to committees, your policy?
Well, the policy is still in draft.
Correct.
So I guess I'm curious, what's missing? I don't have the...
I can explain the purpose of the motion. The agenda that was circulated to each of the commissioners had 3 items on there. Number 1 was approval of the Legal and Governmental Relations Committee meeting minutes dated July 18, 2018. Number 2, explanation of fiscal year 2018 law firms changes, it should say charges. And number 3, government relations report. As we arrived here today, there's a separate agenda, a different agenda that has been given to us, which has the same item number 1, as is item number 2, government relations report, and item number 3, council letter, with an attachment, tab 3, that was not distributed to the commissioners in advance of this meeting. And we've agreed at prior meetings that, and I've agreed with executive staff and council, as soon as I became chairman, that the best practice for this commission is to circulate agendas and items in advance in furtherance of giving the commissioners an opportunity to evaluate the matters, to consider what's on the agenda in advance of showing up to a board meeting and being asked to review something on the fly without any advance notice. So, in addition to the statutory requirements that the district operate in the sunshine in the interest of good government, and what's currently posted on our website at this minute, by the way, which I just checked, it is improper for this board to then be changing the agenda, adding things, deleting things, without any participation by the other members of the commission. I think Commissioner Berry has suggested, Secretary Treasurer Berry has suggested that any commissioner be entitled to place anything on an agenda for a commission meeting, for a committee meeting, or for a board meeting. So this also flies in the face of that proposal, which we'll be discussing at the full board meeting. Finally, there is an item on the full board meeting which deals with oversight of legal affairs. So there's absolutely no reason for the legal affairs agenda to be modified to include something that could be discussed at the full board meeting. And I see no reason.
What's your item four that was on the original agenda? I got that on Saturday.
What was item?
Human oversight, legal affairs. What was that for?
I have a copy of all of the agendas.
He's asking when was it moved? Commissioner Klein put in an
Well, I think
item on the
if we're
chair.
asking for counsel.
I'm sorry, I was
well,
just in
we
the middle of
can-
a sentence.
Okay, but if
Commissioner
we're asking
Klein
for legal
put an
advice, we can
agenda,
ask for that.
and
Legal
item,
counsel, Gregwater,
That was put on and taken off by Chairman Klein.
which item was taken off by me?
The item that Commissioner Mullins just asked about.
Oversight of legal affairs?
Yeah, when was that taken off? Because I got the documents on Saturday, which was the board agenda, and I'm looking at three different agendas now.
That's right.
I'm not sure which one I'm supposed to be. I'm asking, when was item number 4 changed?
So,
And who changed it?
I don't have item 4 on either of the copies I have with me. There
I don't
were
have-
changes
I got it
to,
in my packet on Saturday.
I only have 1, 2, and 3. Is there some prohibition to talking about?
no, there is not. And as I said before, there's no statutory requirement or AG requirement to have an agenda. In fact, the Attorney General has stated that an agenda should never preclude discussion of an important issue that the board determines to discuss.
so is there anything that precludes Chairman Klein from putting his agenda item on the legal committee?
So that, well, the chair determines the committee, the agenda, so it's board process.
But I didn't put it on or take it off.
Okay, so do you have an issue with Commissioner Klein putting his item?
None whatsoever. I never objected to it.
So let's modify, if we're allowed, let's modify the agenda to include that. Does that suit your needs?
So number 4
no,
would
my
be
motion,
what?
the motion that's pending is to stick with the agenda that's properly been published on the web and circulated to the commissioners in advance of the meeting, and reject this new proposed agenda, which was just handed to us just prior to the shade session, which we just concluded. That is the appropriate thing to do at this point.
The motion that's pending is to not consider the board letter. I have both the former Attorney General of the state of Florida, Bob Butterworth, and the former President of the Florida Bar, Jesse Diner, here to discuss what the implications, ramifications, and limitations on our powers are, and that is the item agenda board letter. And as Ms. Barrett said, there is no need to even have an agenda item, so I think that that's properly before us.
Well, Commissioner Gregoire, I may just caution you in terms of the way you proceed today. When you were sworn in as a commissioner, you thanked Mr. Butterworth for being appointed to this commission, to this board. And Mr. Butterworth is a partner or otherwise connected with Buchanan, Ingersoll, and Rooney, as I understand it, which is the firm that sent that letter on September 21st. So I think that I would just caution you to proceed carefully with regard to this matter that you now seek to add to this agenda at the last minute.
Buchanan, Ingersoll are Broward Health attorneys, and both Mr. Diner and Mr. Butterworth are partners at Buchanan, Ingersoll. So they are Broward Health's counsel.
Okay, and
So-
the person who you thanked for getting you this position.
So let's take a vote on Chair Klein's motion. All those in favor?
Aye?
All those opposed? Nay.
The motion carries.
Carries. I didn't hear Commissioner Berry or
I couldn't
Commissioner
even hear the
Mullins.
motion. I couldn't hear that.
It was Commissioner Klein's motion to not consider the recent agenda item, which includes the board letter to which Mr. Diner and Mr. Butterworth intend to speak.
Hold on. I thought the motion was to use the agenda that was circulated that I have, I don't see any reason why we wouldn't
The one
do that.
The one
I don't know what
the
you're
one in
talking
your board book?
Is that the same one that we're looking at here?
What was sent, this is what was sent to me. It came in a package, all of these things.
Okay, so
And
pick
all
up
that-
your
I'm just-
pick up your folder in front of you and look to see if it's the same.
I hope so.
I would argue that I've got 3 different agendas that are received over 3 different days.
No, it's not the same, but I don't know.
So if you I'm sorry, I know there's a motion. I
Point of
wasn't
order,
done with
is,
discussion.
can Commissioner Wellens vote if he's not here in person?
Yes,
What's the authority for that?
the law,
Which law?
probably our charter. There's nothing says that you can't vote remotely, and it's been done all the entire time of the district.
Okay, can you give me a bylaw or some charter
Sure.
reference? You don't have one handy, do you?
I do not.
Okay.
So can I just understand what we're talking about here? So Commissioner Klein
I just
wants
don't
to
understand.
put an item on the agenda. Commissioner Gregoire has a different item on the agenda. Why don't we just put both of them on the agenda and move on?
Well, the motion has been made and voted on and failed, passed, so it passed 2 to 1.
Well,
It didn't pass.
I didn't hear, I couldn't even
That's
hear the
absolutely
vote, so I didn't vote because I couldn't hear it.
Well, there were 2 in favor and 1 opposed, so that means the motion carries.
Everybody has
Is
to
there a
vote.
different interpretation of how you count that?
Yeah, no, it's not an interpretation of counting. Everybody has to have an option to vote. Commissioner Berry, did you vote?
No.
Commissioner Wellens, did you vote? Commissioner Wellens didn't even hear.
No.
Okay, so now you're gonna attempt to avoid the vote?
The vote wasn't completed. You rushed to judgment to say a vote was passed
Okay.
because you don't want the council letter on the agenda.
Listen, I'm happy to discuss the council agenda. I'm proud of what I did, so I'm happy to discuss that. It's improper and a potential violation of the open meetings law to be adding things on without noticing the public. It's just improper practice, and it's just, even if it's technically
Not violative of the
allowed.
statute.
I mean, respectfully, council, you've got other commissioners indicted, for open
Oh,
meetings
that's
law
such a
violations.
lovely-
I do not want to be indicted for an open meetings law violation, so I'm not comfortable proceeding with an agenda that was not circulated to the public, and it was not posted on the web, and it was not even provided to the board members until we arrived here today. That's just not good practice.
So let me, I've got to watch this process. I think I made a reference to at a previous meeting about sausage being made and how ugly that process is. The reason I proposed the agenda's process was because of situations like this. People are changing the agenda constantly. It's not just this one, it's all of them until the very last minute. It's not fair to staff, and it's not fair to the board members who have to read and get up to speed. So I understand what you're talking about, but the same goes for everybody else. This thing has changed. My intent in the in putting forth the agenda rules was to avoid things like this. We didn't vote on it at the last meeting. I'm hoping that we fully vote on it today at the board meeting, which is on the agenda. There is no reason why we can't discuss, except for all the time we're taking discussing the discussion, there's no reason why we can't today discuss each of these items. They're public, it's public information. If we need to vote on accepting or not your Commissioner Klein's proposal, let's do that, and then I may have a counter proposal. So do we need to do that again, or?
Well, in my view, the vote wasn't completed because 2 commissioners didn't even have an opportunity to vote.
Well, I think that I disagree with that, and respectfully, the vote was called and took place. I don't know under what legal basis you're saying there was an improper vote.
Commissioner Wellens didn't even hear the vote.
So then,
I didn't even get, you guys didn't give me a chance to vote because I couldn't even hear it.
so let Commissioner Wellens vote.
And Commissioner Berry, I don't know that you voted, you can't abstain, yes or no?
The question is, are we going to proceed with good governance, or are we going to not do that? And that's really the fundamental question.
Or are we going to let the public
Are we going to
hear
operate in the
an
sunshine?
issue that there are attorneys here
Respectfully,
to-
when we want your opinion, counsel, we'll ask for it.
Okay,
I think you need to I think we just need to take a step back here. This is a little too personal, whatever's going on. I think we should go back, call the vote, give us all an opportunity to vote, and let's move on to the next item that we want to deal with.
But we're still waiting for a vote.
then I vote no.
What are we voting?
Voting on Commissioner Klein's motion, I believe.
But I want
I
to,
vote no as well.
so, hold on, so,
Do you understand what you're voting on, Commissioner Wellens?
So the motion fails.
Does Commissioner Wellens understand what the question is on the table? There seems to be a communication
Yes.
issue here.
No, I don't communicate together because I didn't hear you guys call the vote before. You hear me now, I vote no. I do not think that we should have to go back to an agenda. The agenda is, there's not a legal reason why that we can't consider the items that are on the current agenda. Unless the legal advice says that we can't, that's not the advice we're getting. I believe we can take up the agenda as it is.
As which is? Which agenda are you referring to?
Agenda number 4.
All right, so let's move
I
on to
only
the next.
have one agenda.
The vote has been taken and the motion fails. Let's move on to the first item,
The
which
one,
is,
government relations and the council letter, that's what's on the most recent agenda I'm looking at. I don't have a problem with it. If you want to add items to it, we can add items to it.
all right, let's move on to the next item. The next
Well,
item
I would make a
is,
motion then to add the item onto the agenda, which was noticed to the public and which the public may be here to discuss, which is explanation of fiscal year 2018 law firm charges.
do I have a second to that motion?
Second, that's this agenda. You guys are losing me. I'm sorry.
Commissioner
Maybe I'm
Klein
just a little
asked you
slow.
to add his item that was already previously done to the agenda. Your first motion failed. The first motion failed that said, we're basically gonna use this.
I
Now
understand,
you wanna
but-
add.
Right, but what I recall is I said, is there some reason why we don't want to discuss what was on this agenda? And I thought Commissioner Gregoire said no. and
Commissioner
it's
Klein
fine.
asked to put it on.
That's fine.
You seconded it, so
But
let's vote.
in your chair, so I thought that meant we were gonna at least keep what was previously on the agenda.
We are keeping
Still on.
those, and now Chair
So
Klein
we're
would
gonna
like
add a
to
fourth
add something,
thing.
right?
Okay, so I'm fine with adding a fourth thing. I don't have any problem with that.
And that is the motion, to add
Yes.
on as another item, which was on the draft of our prior agenda, the one that was published and remains on our website, explanation of fiscal year 2018 law firm charges.
There's been a motion and a second. All in favor?
Aye.
Aye.
All opposed? We'll add that item to the agenda. So now we'll move on to the first agenda item, which is approval of the minutes of the July 18th, 2018 Legal Affairs and Governmental Relations.
Chair Gregoire, I have another point of order. At a 2016 board meeting, this board voted to require all council in attendance who are being paid by Broward Health to introduce themselves and to appear. I don't believe that policy has ever been changed. So if we could have every council on behalf of Broward Health do that. I think that would be-
Hold on a second. I read that. I read that, and I believe that was for a board meeting, not for the Legal Affairs Committee. Is that right?
Yes.
It's for the board meeting, not for
Correct.
Legal Affairs.
But I intend to introduce Mr. Diner
No,
and
what that
Mr.
means,
Butterworth anyway.
I'm sorry, Commissioner, but what that means is every attorney here who is representing Broward Health needs to stand up and identify themselves. That's what
Oh,
that's what they're
that-
talking about. So that, from what my read of
I
that,
don't know who else
was
would
that
be.
happens during a board meeting, not during a committee meeting.
My understanding
Well,
is that it
that
was
is my
any meeting
understanding
of
of
the
what
board.
happened, yes.
My understanding is it was every meeting of the board, including committee meetings, particularly meetings at which every member of the board is present and a member of.
If in fact I don't have an issue with it, but I read it to be the board, for the board meeting.
I don't have an issue with it either.
So,
All right, so
go ahead and do it.
Okay.
All right, so any attorneys here who represent Broward Health in any capacity?
Good afternoon, Commissioners. Jesse Diner from Buchanan, Ingersoll, and Rumi. I also have with me here Bob Butterworth from Buchanan, Ingersoll, and Rumi.
As a courtesy to you, if you'd like to take your agenda item out of order,
Doesn't matter to me, whatever the chair wants.
then if you would go to agenda item number 3, which is the letter.
Point of order, that's not an appropriate action item.
We don't even need an agenda, if you can take it.
Well, we do have an agenda, and we just spent time discussing the agenda, and I think the agenda needs to be followed.
So you wouldn't accord these gentlemen the courtesy of letting them give their presentation?
Well, we haven't even heard from the public yet. No, I don't believe it was. My point of order was made prior to the call for public comment, or perhaps at the same time.
All right, so let's go back.
Jesse, please, thank you.
Sure.
Let's go back to see if there's any public comments.
There's no other council here who are being paid by the district?
No, we have the public comment.
Yeah, final rising from fully in order.
Well, does that, Diana,
I'm
aren't you
sorry,
an attorney?
Gabe Emperado, I believe, is here. brought into South. Yeah, we use brought into South, and that you may not personally have, but brought into South represents the district. Yeah.
We
We
can.
have a contract.
But we do have public comment.
Vicente Thrower, I'm a community leader.
Vicente Thrower, Pompano Beach. To the chairman of the board, I'm a community activist and a community leader here in Broward County. Help me understand the stuff that I read. If this is the agenda, we had a commission meeting last night in Pompano Beach, and that which was presented was advertised a week prior to. How does this board do something totally different? And I'm just not getting here. If I haven't been able to look at it prior to, how do you all just add and subtract without letting us know? What if I had other people who wanted to come in also look and weigh in on what you're about to discuss today, Madam Chairman?
Well, I think Ms. Barrett explained that to you. This is a committee meeting. Not the board meeting can't change. I agree with you. But this is a committee meeting, and there's no prohibition, legal prohibition against changing the agenda of a committee.
Well, we have committee meetings, and we call them workshops in the city of Pompano Beach and in Broward County. And even at the workshops, we still have to advertise and tell people what we're going to be discussing. And I'm just curious, because here's the thing about it. What if we wanted to weigh in on something? Even though this may be a committee meeting, I don't even know what this is. But if it affects how we do business, should we, as the shareholders, be allowed to come before you all and talk about it?
You're right. And that is exactly why Commissioner Berry has drafted a resolution, a proposal that will govern in the future so that these things don't happen. This one was very unusual. It came up very suddenly, and we thought it should be addressed at a public forum.
We are having some serious things that this board committed to us of transparency and trust. If we cannot trust and understand what is going on, Madam Chairman, we have to stick to that commitment.
This is an issue of transparency. I guarantee you, when you hear this, you will understand why it's very important that it be before the public now.
And if it's such an important issue of transparency, why wasn't the public given notice of it? The letter was actually circulated to all the commissioners on Friday evening by the General Counsel. It was attempted to be inserted into the agenda last night by General Counsel.
Sir, I agree with you. You're exactly right, and that's why we do have a rule at the board meeting that is going to lay that out. And I'm sure it's been done by previous boards too. This can't be the first time this has been done. In my opinion, it hasn't been followed. It needs to be followed, and that's why I've asked for the board to consider some very stringent rules so the public would be able to see what we're going to discuss. I chose to include everything anybody wanted to discuss on this because I don't think anything should be held back. But I agree with you that you need time to prepare.
And to the chairwoman, here's the case. Even if we had time to prepare, unlike a commission meeting and a county commission meeting, we're not allowed to engage and ask questions before you all have a discussion about this. This has to do some also with the board. So I'll be asking this question to the board. We are not allowed to ask questions about agenda items. So now there's something on the agenda that we don't know nothing about, and it's added to the agenda. And I hope that the legal counsel and you all get together and allow a different open process so that we, as the shareholders, who also are the ones who talk to the governor and write others, it ain't just a little group, it's us, can actually have some input and understand what it is you all are discussing and voting on. This is transparency.
We fully intend to do that. By this time next month, we will have an agenda program, an agenda protocol, and this won't happen.
And I hope that in the regular meetings, when you have an item like commission meetings, that others can sign up to have a talk when that item, before you all deliberate on that item. Because it doesn't make sense to us that we see things on it and we can't even have a discussion about it. And it's our money.
Are you referring to public comment?
Public comment too, I'm talking about that too.
And
the process is not making sense to me.
And that will happen also.
Thank you.
Any other public comment?
Former Commissioner Coble.
As you know, I sat on this board 4 years. I also sat as chairman of the Insurance Advisory Board for the city of Fort Lauderdale. Madam Chairman, I have never, ever, in the 4 years that I sat here, saw as many changes at the last minute as has happened under this general counsel and on this board. It is shameful. The public has the right to know in advance. And I agree with Chairman Klein. This is a disgrace. In the city of Fort Lauderdale, if it's not an agenda item and it's not on there and it wasn't a public notice, we can't have that meeting. We cannot go by a different agenda. So I hope that, I'm sure you have legal counsel representing you here. I hope that you keep that in mind, because everybody is very upset at the fact of what is going on. There has never been more add-ons or changes on this board since this general counsel has been on staff.
Thank you. Any other public comments? No. Okay. So now we will go on to the approval of the Legal Affairs and Governmental Relations Committee meeting minutes dated July 18th, 2018. Do I have a motion to approve the minutes?
So moved.
I just have one typo correction. It's on the vote, on the first I think it's the motion made by me about, it says motion carried 3-1, it should really just be 3-2. Looks like everybody voted.
I think
On
that
the
was,
motion,
I think that was corrected in the,
just a typo, it's not, you know, the motion passed 3-2, I think, not 3-1, unless somebody didn't vote, which is not indicated, that's all. It's the second to last motion on the minutes.
no, I agree with you. That was a typographical error.
Okay, otherwise,
So do I have a second? I have a motion. Do I have a second?
second with the correction.
All in favor?
Aye.
All opposed? Okay, so on a less controversial note, Ms. Artiega is going to give us just kind of a brief overview of what she anticipates will be coming up with governmental relations and what she's engaged in at this moment.
Thank you. Good afternoon, Madam Chair, members of the committee. Just very quickly, I just want to let you know we passed last month the Senate deadline for claims bills, and no claims bills were filed against the hospital district, so that's already good news. I was informed by the Early Steps Program Association. There's about 15 Early Steps programs in the state, one of which is housed by our CDTC in Fort Lauderdale, that they're going to be requesting an increase of $7.3 million in recurring general revenue statewide, and typically every year we support our Early Steps program, so that's something that we will continue to do moving forward. And two quick updates on lawsuits that have been going on since the session ended, and I know General Counsel is aware of these. In early September, the Florida Association of Health Plans filed a lawsuit against ACA for correcting the EAPG outpatient rates that would have given money back that hospitals were suffering from a shortfall from the rates being miscalculated. The Florida legislature had directed them to correct those. So the FAHP filed suit for ACA to reverse that decision, and they voluntarily dismissed their lawsuit last week. So that's another piece of good news for the hospital district. And last session, when I gave my end of session report, I had reported on the trauma bill that passed, which capped the amount of level 1 traumas in Broward County to 3. Which is also good news for us. Unfortunately, there was one safety net hospital down in Miami that was not happy with the bill in its entirety, which was Miami Children's, and they sued to overturn the entire bill. That is still ongoing. But just to let you know that HCA and Jackson Memorial Hospital have intervened on behalf of Kendall Regional. So that's ongoing. If there's any significant news, I'll make sure to report back to the committee and let you know of the status of that.
So this should be a calmer legislative session than
Oh,
last
no.
year?
No,
Won't be.
never is.
Are there any questions of Ms. Artiega? All right, thank you very much. Good
Thank
luck
you.
this year.
Look forward to seeing you all in Tallahassee next year.
Next agenda item is the discussion of the council letter. I'd like to invite up Mr. Diner, Mr. Butterworth, or both.
Thank you, Commissioner Gregoire. Commissioners, again, I'm Jesse Diner. I'm from the law firm Buchanan, Ingersoll, and Rooney, and I'm more than happy to discuss the letter that I wrote on behalf of the firm on the 21st of September, and we'll certainly answer any questions that anybody might have. Let me explain to you some background.
Mr. Diner, can I ask you a question at the outset?
Certainly.
Whose behalf were you writing the letter? Who was your client?
My client is the Broward, North Broward Hospital District. That's my client.
Okay, because the letter reads, our firm performs work for the North Broward Hospital District as outside counsel on certain matters, including governance.
That's correct.
Like, it does not say that you're writing a letter as counsel for the North Broward Hospital District.
Well, certainly, Mr. Klein, I was not a volunteer, okay?
Okay, so
I wrote this letter. I was contacted originally by general counsel.
can you tell us when?
It was I think it was Thursday or Friday. And it had to do with the fact that you had written an email to general counsel where you had certain things in there, and more particularly, I was asked to focus and give my opinion as to what the rectitude of the last paragraph of that email, where you demanded that the investigation that was being done as a result of the July 23rd IRO letter be ceased immediately. I was also informed that you had called Mr. Bittman.
Well, just for purposes of accuracy, can you actually state what was in that email?
I have it. I'll read the verbatim.
Yeah, please.
Verbatim, okay? So that there's no misconstruction.
Absolutely.
About that. Paragraph 4. There's no reason reading the others because my letter had nothing to do with what was prior to it.
Well, I actually think that they may be relevant in context.
Well, certainly you're free to publish it, but I wrote with regard to the last paragraph of your email. On a more serious note, it is my understanding that you have retained the law firm of McGuire Woods to conduct some sort of investigation relative to the flawed IRO report of July 23rd, 2018. No such investigation has been authorized by the Board of Commissioners and must therefore cease immediately. Kindly copy me on correspondence to McGuire Woods ceasing that investigation pending board review. Sincerely, Andrew Klein. That's exactly what you said.
Thank you.
I then reached out to Mr. Robert Bittman at the McGuire Woods firm because I wanted to hear firsthand what his discussion was with you. And Mr. Bittman informed me his version of your conversation with him, where you asked him what he was doing, and you asked him at least 2 or 3 times to cease doing what he was doing. And he told me that at that point in time, he informed you that he would not do so. And as a result of looking at that last paragraph of your email and talking to Mr. Bittman, and also as a result of the fact that back in August, I was asked by general counsel to look into the issue of oversight and board, what the board had authority to do and didn't have authority to do. And that's why we were hired a long time ago to do governance or to advise the general counsel and the district on governance, dating back probably to September of last year, maybe earlier. And so I had been working on a letter of opinion as to what powers the individual board members, the board as a whole, has under the enabling legislation as amended, its bylaws, the Attorney General's opinion of July 2011, and so I had been working on that. So I was very familiar with what the board powers were or were not. And as a result, I issued the letter to you, Commissioner Klein, on Friday. And I wrote that letter because I thought it was important on behalf of the district to make sure that nobody runs afoul of what their authority is or isn't. It was not addressed to you on a personal basis. I've only met you on 1 or 2 occasions at board meetings. We do not know each other otherwise, and certainly nothing personally was meant about it. But it was basically my interpretation of the enabling legislation, the bylaws, and how that affects what board members can do, what they can't do in light of the legislation. And let me give you a brief overview of that. There has been legislation, especially creating this district since 1951. It's gone through numerous iterations. In 2006, 2006-347 was enacted by the Florida legislature, which basically recreated the district. And it's about a 30-page document. Interestingly enough, in 2007, and looking at some legislative history, because I was curious how this came about, who did it, and who sponsored it. Then State Representative Jack Seiler sponsored a bill before the legislature, which was unanimously passed by the House, 116 to nothing, and unanimously passed by the Senate, 38 to nothing. And that's 2007-299. And it basically, it's very interesting because it really lays out the difference between management and oversight. And it makes a legislative finding that mandates that the board not interfere with management. It makes an explicit finding that the board not interfere with the president, CEO, and people working for her. But it also makes a more general finding in the two prior sentences that the board not interfere with any management that's going on in the district. That includes the general counsel who works for the board. General counsel is hired by the board, can be fired by the board, but if you were to take an org chart, general counsel will come directly under the board, just like the president CEO does. The general counsel doesn't answer to the CEO, doesn't answer to the president. And so it clearly delineated that the board must only act as a whole, may not act individually. Yes, individual board members may inquire or question about something, and they're free to do that, but they are not free to direct anything. And no one board member has any more authority as chair, vice chair, or any other officer than the rest of the board. It all is that the board acts as a whole. And let's fast forward now from 2011, when that act was passed, to 2011, when then General Counsel asked for an Attorney General's opinion from Attorney General Pam Bondi. And there were three specific questions with regard to that. Was how does the board exercise oversight in light of legislation 2007-299? May the board give direction or interfere with those under supervision of the CEO president? And there's a malfeasance provision in the 2000 legislation. How is malfeasance enforced? Those were the three questions. And General Bondi, and I'm not going to bore you by going through it because I can be happy to supply that opinion to anybody who wants it.
We have it in the
Okay. So General Bondi went forward and gave that opinion. And it's interesting because Attorney General these days does not give too many opinions. That was the 12th opinion in 2007. It was in July of 2007. My partner, Bob Butterworth, said that when he was Attorney General, they used to do about 90 opinions a year. But for whatever reason, there are less opinions that seem to be sought or given at this point in time. Fast forward from July of 2011, and in November of 2011, the board did its about 13th iteration of the revised bylaws. And the board enumerated in the bylaws the different authority of the board, committees, individual board members, officers of the board. And it's pretty interesting because those bylaws do their best to track the 2007 legislation. So it's clear in your bylaws and the enabling legislation as amended that this board must act as a whole. It certainly has an oversight duty, but oversight is different than management. It cannot micromanage. I mean, and I'm not exactly sure, but I will talk to Jack Seiler, and maybe if I get some more insight into this, I'll be happy to illuminate the board about this as to why somebody wanted a specific legislation to create this separation between oversight and management. It's pretty interesting because here you've got 30 pages of enabling legislation, which gives all these powers to the board for this special district. And then you've got an act a year later, an amendment that makes it very clear that the board can't micromanage, and one individual cannot act without the authority of the board. And now you overlay the situation that you're also under a CIA since the end of August 2015, and the board has oversight duties under that CIA, and there's no doubt about that. I believe, my opinion is that those duties mesh with the enabling legislation that the board entered into in the CIA, that it had authority to enter into. And there are certain obligations and resolutions that are required by the board to the OIG. So the board has obligations, but more specifically, one interesting thing in the original legislation in 06 says that it shall be, and I think it's provision 33 or 34, right at the end, shall be liberally construed to give effect to the act. Well, that wasn't amended. So there should be a liberal interpretation of the act as amended to give effect to it and not to have any kind of interpretation that would in any way be kind of an absurd interpretation. That's the whole purpose of that. I'll be happy to answer any questions, but I hope this answers why I wrote the letter, the background for the writing of the letter, and my rationale for the opinion that I expressed in the letter.
Thank you. Are there any questions of Mr. Diner?
Yes, being the recipient of the letter, I'd like to address a few items that have arisen, and I'm pleased that Mr. Diner has written a letter. I think that it's important that we all recognize that we must act as a board, and that it was precisely the reason why I took the actions that I did. And I'll relay what has transpired. Mr. Diner, I think you mentioned that this Board of Commissioners has a duty of oversight and independence, correct?
Correct.
Okay. Let me read the email that I actually sent to Ms. Barrett on Friday, September 21 at 5:26 p.m. Actually, that was, I sent it on September 20th at 10:58 a.m. And then she circulated to the full board that evening. The letter says, Lynn, it is extremely disappointing that you have failed to provide the simple list of litigation and investigations requested nearly 1 week ago, and that was promised early this week. This is a report that surely should be maintained, as a matter of due course and routinely presented to the Board of Commissioners, and with 14 FTEs, full-time equivalents, in your department should be easily produced. And I would just note as an aside that I still have not received that report in its entirety. We received a partial report that was sent to the entire commission. The next paragraph of the letter says, I attempted to reach you today, through your office phone, mobile phone, and secretary, and have received no communication back from you. I am told you were out of town, though had no notice at all of that. Going forward, please advise me, Patricia Alfaro, and Beverly Capasso in advance, and you'll be out of the office, for what reason, and who is covering for you while out of the office. And the third paragraph is the paragraph that was read previously. At the prior board meeting preceding this, and the reason why I asked for that report is this board has received almost no information concerning ongoing litigation. In fact, at our prior board meeting on September 12th, the board asked to schedule a shade session for today to get an update from the law firm of Foley & Lardner with regard to ongoing litigation, which is costing this district hundreds of thousands, if not millions of dollars. And counsel apparently was unable to produce an outside counsel to come and brief this commission as to the status of litigation on 2 weeks' notice. I don't know, I never got an explanation as to why that didn't happen. So clearly there's certain actions that the general counsel is not taking, but yet certain actions that she is taking. And during a briefing last week on September 18th, I believe it was, I was advised by Ms. Barrett that there was a new investigation that had been undertaken. Actually, I asked her about it because I had heard through the grapevine there was some investigation that had been undertaken. And I asked Ms. Barrett, General Counsel Barrett, who's running this investigation? And what is it? And she said it was Bob Bittman of McGuire Woods out of D.C. And notably, at the prior board meeting on September 12th, we had a lengthy discussion with regard to the need to stop the infighting, to stop what's happening at the system in which there's the constant tension between the general counsel and executive management, and even tension now at the board level, which has interfered with the ability of this board to do its work. And everyone agreed that is the objective. But nonetheless, about 6 days later, I was advised that there is in fact an investigation ongoing, which was not authorized by the Board of Commissioners, and of which the Board of Commissioners had no notice. And that is one item in your letter with which I do take issue, and which you referenced. You appear to reference Ms. Gregoire, Commissioner Gregoire, providing some type of information to the board with regard to this this investigation. But that never happened. So that is one item that is in your letter of September 21st, which I do believe is not correct. I spoke to Mr. Bob Bittman of McGuire Woods on September 20th, and I asked him, what is this investigation that you're undertaking? As a board, we have no notice of this. He said he was to review the issues and the response and the allegations relative to the July 23rd report of the IRO. He said he had executed an engagement agreement, and he was interviewing people, reviewing documents, including senior management and board, although I hadn't yet been contacted. I don't know if anyone else had been contacted. We have not, as a board, considered this matter. He specifically referenced what he called the core allegations of the IRO report and was asked to do an independent review. The form, he said some report, the form had not yet been determined. I asked him if there was a budget for this independent evaluation that he was undertaking. He said there was no budget that was established. So there was no budget and no report and no timetable for any report to be produced. He said he had not considered whether Lynn Barrett had the authority to act. When I asked him if he had thought about that concept, since again this board has the authority to oversee general counsel and to authorize investigations, and I advised him that he may want to stand down on that investigation pending board clarification, which I think is consistent with what you're telling us, that the board must act as a whole with regard to any action the board wishes to undertake.
That's true as to action, but an investigation is not necessarily action, sir. So that's where I disagree with you. Any committee under the bylaws has the authority to investigate either on the authority of the chair, the board, or on its own authority. That's in your bylaws.
Okay, and
general counsel, let me finish, and then, because I'm not here to argue with you, I'm here to try to answer questions. And general counsel under Roman numeral 5-7, particularly subsection B, has the authority to direct and control legal affairs of the district. It's true that general counsel answers to this board. General counsel can be hired and fired by this board, but general counsel has the authority because general counsel acts just like the CEO does of general counsel's management area. And so general counsel has the authority to undertake that investigation. And if I misspoke in my letter that Commissioner Gregoire reported on that investigation, and I apologize, but I was under the impression that she had reported somewhat about it. And if I'm wrong, I apologize. But there is authority to do that. And if for somebody to, one board member, to then say cease, that's when one board member is micromanaging or possibly interfering. That's where we may have a difference of opinion as to where this sits. I understand. There's always, just so you understand, and it's not easy, there is always a tension between, when you talk about governance, between oversight and management. There is always a tension. And it is not a totally bright line. I think it's a pretty clear line under this enabling legislation as amended and under your bylaws, but it's not a bright line.
Okay, but you'll agree with me that the segregation in the charter deals with management reporting to the CEO.
Not only, read the prior two sentences, sir.
Which section are you referring to?
I'm talking about in section 5, subsection 2. I have it here, and I'll be happy to hear it.
It is in the finding of legislation is not in the public interest for any member of the board.
It is in
or
the-
commissioners
it's in that
to operate in the perceived role of management while simultaneously exercising the charter oversight duties contemplated by the creation of this special act. It is therefore the intent of the legislature that the Board of Commissioners only exercise its oversight function as a whole body and not through the actions of any individual commissioner. It is also the intent of the legislature that there be an explicit segregation of duties between the functions of operational management of the districts and oversight by the Board of Commissioners. Except for purposes of inquiry or information, a member of the Board of Commissioners shall not give direction to or interfere with any employee, officer, or agent under the direct or indirect supervision of the President/CEO.
So the sentence before except is a broader thing, that the board shall not interfere with any management. And
is general counsel a management?
General counsel manages the legal affairs of the district. Yes, it does.
So what's the legal support for management being, for a general counsel being considered management within the context of this statute?
General counsel, number 1, does that, and general counsel, under your bylaws, directs and controls all legal affairs. That's management.
Okay, well, the question then becomes, is this a legal affair or is this a compliance matter? Because if the IRO report is under our corporate integrity agreement, then it's a compliance matter.
It's probably
the IRO is a requirement of the corporate integrity agreement.
I agree, but it's probably both, sir.
Okay, so when I asked that our compliance officer also directs to the board, or reports to the board,
that's correct,
whether he was aware of this investigation, he said no. He said he had no notice this investigation had been undertaken, and that his first notice of it was on September 4th when he was being interviewed himself by this outside law firm. So if it's a compliance matter, then why is our chief compliance officer involved with it and making that decision together with our general counsel? There's just no reason why that would happen.
I can't speak to that, sir. I can't speak to that.
I don't think anybody could speak to that. And when you compound that with the fact that we had a board meeting and committee meetings in the intervening weeks between me finding out about this evaluation, this investigation that had been undertaken, and the initiation of this investigation, we have to wonder as a board why we were not advised of this. Why there was not a shade session called to advise the board as to the fact that there was an investigation that was necessary, if it was indeed something to be handled in the shade as opposed to the sunshine. So there's a lot of questions surrounding what this investigation is and who has the authority to undertake it and what the objective is and what it's going to cost the taxpayers of this county. And that's something the board, as in its duty of oversight and independence, needs to know. And that's what we need to determine as a board. I think each of these board members should be offended by the fact that this is going on and that we did not hear about this. We did not hear about the IRO, the matters in the July 23rd IRO report until that report came out. And yet we had board meetings while that was going on. And while our general counsel and our chief compliance officer knew those issues were being investigated by the IRO, but yet did not inform this board that those things were going on. So again, there's a lot of questions that we have, and when you compound that with the multiple failures of our general counsel to even perform the most rudimentary tasks, it's very frustrating when I find out that I can't get information from our general counsel, I can't get a legal memo from our general counsel, but yet she's traveling somewhere and she's doing this investigation, which is arguably not even within the scope of her authority. And the review of our general counsel is something that is long overdue by this board and that we need to be undertaking. And that's, I think, underlying some of the aggravation that you're hearing today with regard to the millions and millions of dollars being spent without very little oversight and almost no reporting by the general counsel to this board.
Well, sir, I'm only hearing the aggravation from you, but that doesn't matter. Certainly you have an oversight obligation. That's your job as commissioners. There's no doubt about it. Whether that translates into micromanaging or being able to do more than ask questions, when you write in your email, and I wasn't going to comment on this, but you read it. When you write in your email, you need to tell me when you're going to be out of town, and tell the CEO when you're going to be out of town. I'm not so sure that that is your purview. Now, the board as a rule, as a whole, could possibly direct that, but you as chair don't have that authority. You're just one commissioner.
So you're saying that I can't mandate that a direct report let me know when he or she's going to be out of town?
Direct report to the board,
Yes.
board, not to you, sir.
Okay.
That's the difference.
Okay, so So we need, as a board, to adopt a rule that the direct reports let us know when they're out of town. I actually thought that it was something that we had discussed and that the direct reports were pretty clear on, that they were to advise us as to their availability. But perhaps that's something that we need further clarification.
I don't know. Do you have the CEO reporting the same way?
I do.
When they're going to be out of town, when they're in every day, do you take attendance? Is that what you mean?
No, if there's going to be unavailability, I mean, we have a duty, of inquiry and oversight.
I agree with
and
that.
It's impossible to fulfill that duty if we don't know who's available and who's not, particularly if they're out for extended periods of time. I requested, for example, from General Counsel, a copy of all the engagement agreements with all the various attorneys to whom we hand out millions and millions of dollars. And yet we still can't get the physician contracts approved by the Office of General Counsel. And I asked for those, and I was told, "Good evening, Commissioner. I conferred with Commissioner Gregoire, the chair of the Legal and Governmental Affairs Committee, and I will begin gathering the responsive documents, which will take time. Thank you, Lynn." Now, why would it take time to produce engagement agreements with our attorneys? And why would that be something that she would need to confer with Commissioner Gregoire on? You yourself just said, we can only act as a board. So if the General Counsel feels that she can't produce those engagement agreements to members of the board, she needs to present that question to the board, not to an individual commissioner who has no authority to tell her one way or the other. Isn't that correct?
I don't believe she ever said that she needed my permission,
What was the reason she conferred with you?
just to let me know that you had requested that. That's it. And a request that, by the way, should have been communicated to the entire board, not from one commissioner directly to Lynn.
I don't communicate with other commissioners outside of publicly noticed meetings. And I do want to state for the record that I want that practice to cease, Ms. Barrett. So I do not want to receive any more emails that include other commissioners on it. I do not want to receive communication that was sent by another commissioner to you that you're forwarding to members of the commission. I just want to make that clear.
Any other questions for Mr. Dyke?
No, hold on, please. Mr. Diner, you were referring at one point to Sam Gorin's email
Yes.
to the Attorney General.
Yes.
Yeah, I have that. I also have legislative intent. I have an issue with the just backing up and a little bit off topic of the interference clause because it's being thrown in our face for a lot of things. I do think the board as a collective can write policy and control what the district does, and that's what I intend to make sure this board does through policy.
That's true.
Directing what we do. We have a lot of, in the charter, there's a lot of things this board's responsible for. Getting into the minutia of the day-to-day operations is not one of them, but asking questions is.
Certainly.
When I read this, it's definitely much more about the individual actions versus the collective. This board can almost do anything in the appropriate format in the collective. It's individual. And I believe that's what you were saying. In the beginning, you said the commissioners couldn't do anything. You meant that to be individual, not as a whole.
That's correct. Absolutely. I mean, the legislation is very clear.
Yeah.
The board acts as a whole.
I just have issues. I've only been 4 months, I think, and I've heard interference a bunch of times. That's why it's actually on the board agenda for later to make sure there's some clarification, because as a new commissioner, you want to know what you can and can't do. When you see something obviously wrong, you want to jump in, but there's some restrictions. You have to wait for a board meeting. We do not communicate between board meetings, so this is why you get to see such a wonderful process play out in front of you, because we don't get to talk to each other, so we have to do that here and have some debates. There's obviously in the communication lines here something very, very broken, but we did know about, we were informed by Ms. Barrett that this investigation was going to go on July 25th or July 27th. I believe at that board meeting, it was my second one possibly, and I was struck that she was able to do that, by the way. This isn't a defense of where we are, but it was a surprise to me. When I read the IRO letter, I took that to heart and very seriously. In fact, to say the IRO letter had what wasn't correct is not correct. 2 people have been terminated as a result of it. 1 person was suspended for it. Other actions have been taken, so there's meat in there. Something happened that shouldn't have happened, and I believe...
Well, Commissioner Barrett, I'm not sure those terminations resulted from the actions referenced in that report.
I believe they were. Well, we can get clarification, but I think they were, and I actually kind of hope they were, because I think those actions needed to be taken. But in that meeting, we also talked about having an independent, the IRO left a lot of things for us to discuss. it led us to a point and then said, it's up to the board, right? You all remember that. It's up to the board to figure this out. The board as a group couldn't really do that. So we talked about hiring outside counsel. I believe Ms. Barrett at the time informed us she had already engaged outside counsel.
I believe I said I was in the process of
Okay.
signing an engagement letter.
And then, I don't know if we took a vote, but the board talked about you working with legal counsel to do that. Now, McGuire Woods, however that choice was made in the end, I don't know, we don't really get involved in those types of things, but I do remember talking about that and knowing that somebody would be looking at those issues in the IRO that basically left it to the board. Board, you need to do this, and I think I even asked the executive team to come back. We wanted to try to get it resolved by the next meeting. That one came up at the last, and that IRO, I think, was 2 days before the meeting, right? And we walked it onto the board agenda. It was a lot to try to take on at once, and it was complicated and cumbersome. But I do believe that Ms. Barrett informed us at that meeting that she was in the process of hiring an outside counsel. So I don't know that that's necessarily true. I tend to agree with you on the one part that some of those things, investigations, should be agreed to by the board before they're taken on, but that doesn't appear to be the practice up until this point. The policies and procedures that I've seen, from setting just the agenda to minutes, have just not really been followed, and we are going to follow them. We are going to get those things written, put in, as Mr. Cobo and some of the other former board members know, a lot of things were done in those other board meetings that don't seem to have been memorialized to give over. This board turns over every 3 or 4 years for obvious reasons. It turns over, and we need to leave in place structure so they don't have the same type of chaos that we seem to be having right now. I really want to make sure, Mr. Diner, that we understand that the board as a collective can do just about anything with this organization. This is, our shareholders are the people who sit out there.
Right.
They're the folks that we tax when we don't make the budget. We
Right.
take their money to pay for this service. I think I answer to the people of the community. I appreciate what you had to say. Sir, I'm sorry, I didn't get your name. I really appreciate that, because I do think the process of getting into these meetings, in fairness to the public, needs to be more transparent. I think it is. I just think it's painful to watch getting it together and the changes that happen. As you see, this one came up on Thursday. This issue came up on Thursday with this letter. That's why there was some tugging and pulling on why it should get in there. But this board has the authority to do a lot, and we need to take that seriously and start managing our responsibilities the right way. I believe we're on, even though it doesn't look that way, I believe we're well on our way to getting there. And I do want to say, though, I clearly remember Ms. Barrett saying that, and I'm sure you have the minutes somewhere, Ms. Barrett saying that she is engaged or was engaging a third party to investigate the remaining parts of the IRO.
And
That's
it
the
was-
question I have. I mean, do we have minutes that reflect that? Because that's not consistent with my recollection. Certainly, if that came up, my recollection of that meeting is that management said they were investigating. The executive management said, we're going to look into the issues raised in the IRO report. It will be producing a response to that report. So I think it would not make sense for the board to have been authorizing or even suggesting to have authorized a follow-up investigation without it even getting a response to the IRO report.
Commissioner Klein, I vividly remember, because I was struck by it, that she had the authority. And she told us, and nobody said a word. So I do,
Well, the CEO and general counsel said they were already starting an investigation or retaining attorneys.
I had no idea who that was or how that was going to operate, but I don't know if we had a motion that authorized it, but from everybody just kind of assuming that it was okay, it seemed to me that we had authorized it or allowed it to go forward. And I've had my interview, and I didn't have a problem with the questions that I was asked. So I think we're going to come to a conclusion on that relatively soon. I know there's no timeline. It petrifies me of the budget. If you know the attorney that was engaged, he is high-powered and I'm sure not cheap. And I hate the fact that we spend a lot of money on this type of stuff because it's taxpayer money that we're spending. And hopefully by year end, we can have more clarity and we won't be doing things like this. We won't get in our own way. That's what this seems. And just as a note to the administrative staff, I would say if they don't get it together, we have the authority to terminate them, and we will. If they don't start working as a team, our job is to make a move. In my company, if my COO isn't working with the team, I will move on that. I will move those people out. This needs to get better fast, the communication internally.
You're just using that as an example, I would imagine.
Any other comments or questions for Mr. Diner?
The only other comment I would make is that there's ongoing concerns with regard to what went into the July 23rd IRO report. As I noted earlier, the board had no indication that there were issues of the nature that were then referenced in that report. They weren't presented, or at least they weren't presented by either our general counsel or our chief compliance officer. And when the board at that meeting, I think it was July 25th, expressed some concerns, or at least certain members of the commission expressed some concerns over that IRO report, there was a follow-up letter from the IRO indicating that the IRO independently presented facts based on available documents, for example, and undertook a substantial effort to document presented facts by including the pages that were included. So the question for this commission is, what was presented to the IRO and by whom? And there's been absolutely no clarity with regard to that, because when the executive team did their response, it indicated that there were serious gaps in the factual descriptions and facts that were purportedly underlying that July 23rd report. So to now be going further down that road, and by the way, to undertake an investigation while that report hadn't yet been responded to, made no sense to me. And if I hadn't heard that at the time, I would have said, well, let's hold on a minute and let's at least get the management response so we know what facts we're dealing with. And there's two sides to the story, and then perhaps proceed with some investigation. So perhaps, if anything, maybe I understood it to mean our counsel and our CEO were actually going to work together on something, which would be remarkable, given the animosity that is just palpable. And it appears to date back to the contract, which, for whatever reason, Ms. Barrett just disagrees with, as she told me last week, which is not a legal matter. And I explained to her that it's a legal matter. If you have an issue with it, please let us know at the board level what that is. If it's a non-legal issue, that matter is concluded, and there's no further reason for you to be upset about whatever the terms are of that contract. But there seems to be an inability to let that item go. So at this point, I mean, what I would like to do is suggest that the board request that the IRO produce a log for us of the communications that preceded the issuance of the IRO report. So we know what information went into that report, since the IRO himself in his August 2nd letter referenced that the report itself was based on facts presented and documents presented. So to me, I think that's the only reasonable step this board can take at this time to get to the bottom of this matter, to determine what was presented and by whom and when.
Well, I think
And,
that's gone far beyond our agenda items. We've already amended them 15 times. I think you can certainly bring that up at an appropriate time, but this is not a comment or question for Mr. Diner, and I'd like to ask Mr. Diner to please finish up. And
I'm really done unless anybody has another question.
Good.
That's fair enough. There is one other item that I would like to note, because you referenced the scope of the authority of the Legal Affairs Committee, which is currently meeting right now. And under our bylaws, this Legal Affairs and Governmental Relations Committee has the duties of the Legal Affairs and Governmental Relations Committee shall include, but not be limited to, reviewing the legal affairs of the district, reviewing federal and state legislative efforts, etc. So while it says including but not limited to, this committee is really, apparently according to our bylaws, has its primary objective reviewing the legal affairs of the district, not necessarily ordering any investigations or overseeing any investigations. That, to me, is a responsibility that falls to the full board at a duly noticed board meeting, notwithstanding the fact that all the members are here. Because as we move forward, it's been my effort all along to get this board to be as compliant as possible with the charter, with our bylaws, and with our corporate integrity agreement obligations.
What I referenced was 4-2, Roman numeral 4-2 in your bylaws. It says standing committees, and this is one of them, legal affairs is one of them, shall investigate and report on matters within their jurisdiction, either at the request of the board, the chair, or on their own initiative, except for those matters which were referred to another committee or the chair of the board. That's what I was referring to.
Okay, thank you. And of course, I just read what their jurisdiction is, so you have to read those two things.
I understand, but I think it's within their legal purview. And there may be things where things overlap. That's possibly true, but I think it was within their purview. So
Those aren't our bylaws.
Right.
Well, thank you for your time.
That's just my opinion. Okay.
Thank you, Mr. Diner.
While we're on this subject, one of the things I have brought up in my recollections in our most recent board meeting, okay, this organization is not always going to have an IRO. This organization is not always going to be under CIA. Okay, we are going to need to demonstrate an ability to investigate ourselves, take corrective action ourselves, and where my concern comes is the failure to allow this organization on its own to have to address these types of issues and take corrective action itself, and allow then the use of Mr. Newton in the IRO as a, let's just say, independent review of the action and the steps to reach that action taken by the district. Because the concern that I have is when we don't have even an opportunity to handle these things internally, when is it that we're going to start? Okay? Because there'll be a day when this is behind us in terms of the CIA and the IRO, and we better have our proverbial, you know what, together as an organization. And that's where my concern comes. Okay? I need to have confidence that as an organization, we can undertake these types of tasks, take the corrective action that's necessary. Because that's what I'm going to need to be relying on at some point. And I don't have that confidence right now because we don't tend to do that internally. And that's where my concern comes. So just stating that.
Thank you.
Need anybody to...
Chairman Klein, the last item is yours.
Yes, thank you, Commissioner Gregoire. What I've asked our executive team to do is print out the list of legal expenses for the last 5 fiscal years and year to date. This is something that we have not been provided with as a board. We've talked around a lot of the numbers about there being millions of dollars here and millions of dollars there. What I'd like to do is distribute those to the board members. Again, since we can't do this outside of a meeting, I'd like to distribute those for discussion here. So the first item is fiscal year 19 year to date. It's being circulated. There's a few copies there.
Chairman Klein, if I could, let me ask you, because we've run over time, for the legal affairs and we're supposed to be in the board meeting, would you agree to discuss this in the board meeting? Because I think you also have it on the board meeting agenda.
So we have legal oversight on the board meeting agenda, which is why I thought the council letter could have been discussed there as well. So let me do this. I'll circulate these now, so the members of the board can have them, and then we can take that up at the full board meeting.
Can I get a copy of that? Because I've got what looks like a spreadsheet, but I think you're looking at a different spreadsheet.
Alan, do we have the ability? Okay, Alan Goldsmith will send you a copy of that.
Okay, with that, any other business? Could I have a motion to adjourn?
So moved.
Second? Second. All in favor?
Aye.
Motion carries.
Can we have 5 minutes?
All right, we're going to take a 10-minute recess, notwithstanding the fact we're over time. Just for everyone's knowledge, we will be taking a recess at 5:30 for the second final tax hearing, to the extent we have not yet concluded the board meeting at that time. Hopefully we will have concluded the board meeting about 5:30, but if not, we will be doing that. We stand and the meeting order has been